All rise. The International Court of Justice is now in session. President Anderson and the Honorable Judge Waslaska and presiding. The case before the court is the case concerning the sister of the son. Parties are applicant the state of Atanya versus respondent the Kingdom of Rahat. The applicant and respondent are each allocated for 5 minutes to present their pleadings.
You may be seated. Agent for the applicant, are you ready to proceed with your pleadings? You may.
Proceed.
You may.
Good afternoon, Mr. President and Your Excellency. May it please the court. My name is Saidisa Sanglafi and I am extremely honored to appear before the International Court of Justice, pleading on behalf of the Federation of the Clans of Watan, applicant in the present proceeding, along with my co-agent, Mr. Ramin Masuri. I will speak for 22 minutes and I will address applicants' first two submissions regarding the inequitable and unreasonable utilization of the water of the aquifer by the state of respondent and the harms caused to the Ken Canyon complex by the Sabali pipeline operation. My co-agent will speak for 21 minutes and he will address applicants' last two submissions regarding the illegal possession of the Ruby Cipher by the state of respondent and their failure to receive compensation for the migration outward. And we respectfully reserve 2 minutes for rebuttal, Your Excellency. Mr. President and Your Excellency, the applicant would like to submit two arguments for the first submission. First, Rahat violated the principle at its unilateral declaration, therefore resulted to the violation of the principle of equitable and reasonable utilization. And second, Rahat caused significant harm to the state of applicant and therefore violated applicant's territorial integrity. Moving to the first argument, Your Excellency. Under Article 1, 4 and 7 of the ILC draft articles on guiding principles applicable on unilateral declarations of states, unilateral declarations publicly made and clear in specific terms are binding over states and creates legal obligation, Your Excellency.
What are the clear and specific terms of this unilateral declaration?
Your Excellency, based on paragraph 16 of the compromise, the Rohari Minister of Water and Agriculture in 1993, in the first World Water Day, stated that the state of Rahat will promise to save the integrity of the aquifer and also to use the water of the aquifer equitably with the state of applicant. But it was 2006 when they started extraction of water at a great rate of 1.2 cubic kilometer of water from the aquifer. And the paragraph 26 of the Agreed Compromise is evidence of this claim, Your Excellency.
But is that clear? You said that the guiding principles require that the statements be clear and specific. What is clear about a statement that seemed to be political in its nature? It was on a World Water Day. It was a diplomatic event, and the statement was such that it was, we will do what we can to use this resource equitably. What can we bind them to behave?
Your Excellency, the time that the declaration was made, it was the time that they were experienced a drought condition based on paragraph 40 of the Agreed Compromise. During 1983 up to 1986, the state of respondent and the applicant were experienced the drought condition. And in 1993, and they were also importing water from other countries. So therefore, it cannot be diplomatic or political statements, Your Excellency. Therefore, as there was the Quinteres was present on that day, the Minister of Water and Agriculture, on behalf of its country, made a unilateral declaration to bind its state under an obligation to equitably share the water of the aquifer as a shared resource, Your Excellency.
Okay, so if that is the case, what are the requirements to have a binding unilateral declaration on a state?
Your Excellency, Article 5 of the ILC draft articles talks that it is not important to be in writing or in writing or not in writing. Therefore, it was nothing else is about the the declarations, the unilateral declarations stated in the ILC draft articles to have more obligation, to create more obligation to the states. It was clear in specific terms, and it was made by a authorized person. Therefore, it is binding over the state of respondent.
Well, respectfully, Agent, Article 4 has other legal requirements that it limits who from a state government may bind a party. Aren't there limitations on which members of a government can bind?
Your Excellency, Article 4 talks about the heads of states, ministries, and ministers of foreign affairs, and other persons who can bind their country, which for the matters which falls under their competence, Your Excellency. Therefore, and as well PCIJ, ICJ in many of its decisions held that this principle or states can bind their countries by unilateral declarations. For example, in nuclear test case, the Ministry of Defense of France stated in 1975 that there would be no other atmospheric tests in 1975, and France is ready to do their tests underground, in an underground tests, Your Excellency.
But the Minister of Defense of France operates closely as a Minister of Foreign Affairs would. The draft articles recognize that it's typically a head of state or foreign affairs minister. A Minister of Defense necessarily, in their purview, acts internationally in character. The Water Minister, however, is a purely domestic function. Has this court ever extended the principle in Article 4 to allow for a domestic minister?
Your Excellency, Article 6 of the ILC draft articles states that the countries can address the whole international community and as well individual states. Therefore, the Minister of Water Agriculture just addressed the state of respondent and the applicant, Your Excellency. Therefore, it is binding on the state of respondent. Your Excellency, furthermore, according to the principle of equitable and reasonable utilization, which is placed in Article 4 of the ILC draft articles on the law of transboundary aquifers, the state of applicant respondent were forced to use the water of the aquifer equitably and reasonably.
Agent, I have a threshold question to your argument. Why is the respondent bound by the terms of these draft articles, if they are indeed draft articles?
Your Excellency, the draft article falls under the umbrella of Article 38 of the ICJ statute. Based on Article 38 of the ICJ statute, customary international law, and also teaching of the highly qualified publicists are one of the sources of international law, and court can refer to them as a source of international law. And the ILC draft article is drafted by International Law Commission, which is contained of the most highly qualified publicists, and also the provisions of the ILC draft article is raised up to the customary international law, Your Excellency, as it satisfies both state practice and open juris, Your Excellency.
Can you elaborate on state practice and opinio juris? How many states can be shown to be following these draft articles, believing that they're bound by them?
Your Excellency, at first the principle of equitable and reasonable utilization is applicable on the whole natural resources of the countries, as it will be on the water, on rivers, on other water courses. And in aquifer, specifically in aquifer matters, there is many specific least aquifers in the world. So therefore, the agreements between the countries, which is made, for example, the Aldesic aquifer, and the agreements of states have contains more some of the at least almost all the provisions which are contained in the ILC draft articles. And as well, the principle of equitable and reasonable utilization is one of the most important principle in this ILC draft article, Your Excellency. Your Excellency, this principle urges aquifer states, even in case of recharging aquifer, not to utilize at a level that would prevent its continuing function, Your Excellency. And based on paragraph 21 of the Agreed Compromise, ELSA reported that as the recharge rate of the inlet aquifer is low, so pumping water from this aquifer will completely deplete it. So, based on paragraph 26 of the compromise, the state of respondent utilized 1.2 cubic kilometer of water from 2006 at the present day. So, it will be completely depleted, and it is against the principle of equitable and reasonable utilization, Your Excellency.
Is Rahad entitled to use of the aquifer?
Yes, Your Excellency. Under Article 3 of the ILC draft article, and based on its sovereign right over its natural resources, Rahad is entitled to use water from the aquifer, as it was doing in the past, based on paragraph, the last sentence of paragraph 14 of the Agreed Compromise. The state of respondent were also drilling wells on private lands in order to use water from the aquifer, but the state of applicant never challenged it, because that use was equitable, Your Excellency. And this use of water by the aquifer, from the aquifer, is inequitable, because it is overexploited by the state of respondent.
What about the consideration that we have a drought? We have a significant need for fresh water sources, and we have a limited amount of fresh water in the respondent's nation. Can't that change our analysis of the factors relevant to equitable and reasonable use?
Your Excellency, the state of applicant do respect this concern, but as the World Health Organization reported that the needs of every person per day is 50 to 100 liters of water, and if we calculate it to the population of the state of respondent, it will be equal to 0.01 cubic kilometer of water. But the state of respondent are using 1.2 cubic kilometer of water of the aquifer. So it means that they are not just providing water for drinking water or for human needs. They are using it for many other things, as
including Atanian refugees, Agent.
Yes, Your Excellency. That the refugee matter also goes to the state of respondent, because the shortage of water in the state of applicant forced it to enact the RAP Act, which is a which is going to be which was a policy by the state of applicant in order to limit the usage of water in the state of applicant as a result of shortage of water by the state of respondent.
Well, let me ask you this. You seem to be arguing with your World Health Organization numbers that the respondent is limited to the use of this water for purely domestic consumption only, for individuals' use for their needs of drinking water. Doesn't the Covenant on Economic, Social, and Cultural Rights conceive of the need to also promote economic activity within states? Doesn't it also speak to the right to food, and a significant amount of the water was going for agricultural purposes to maybe meet those needs? Are you suggesting that Rahad's use of water for those purposes is a violation of their legal obligations?
Your Excellency, based on paragraph 21 of the Agreed Compromise, ELSA reported that in the light of projected consumption, growth and development, completely ending Rahad's reliance on imported water and re-establishing self-sufficiency would require a supply of 1.2 cubic kilometer of water yearly. So the 1.2 cubic kilometer of water yearly was used by the state of respondent for this purposes, Your Excellency, and the state of applicant claims that it is not the time for the state of respondent to re-establish self-sufficiency or completely end its reliance on imported water, because the drought condition and also the climate change shorted the water in the region, Your Excellency. We are facing lack of water. Therefore, their usage of water from the aquifer is inequitable and unreasonable, Your Excellency. Your Excellency, moving to the second argument, Rahad's extraction of water from the aquifer caused significant harm to the state of applicant and as well violated its territorial integrity. The special reporter and the most highly qualified publicist, Stephen C. McCaffrey, stated that under the restricted sovereignty principle and the customary international law norm of sec tutor to ad alienum non lidas, states must use their own property as not to injure their neighbors. And in international water law, a significant harm is one that materially interferes with or prevents a reasonable use of water, Your Excellency. In our case, based on paragraph 27, 28, and 29 of the Act that come from me, small streams, springs, and wells in the state of applicant were dried up, and also
Why did they dry up, Agent?
because of the shortage of water table in the region, and as a result of the overexploitation of water by the state of respondent from the aquifer, Your Excellency.
So the amount of water in the aquifer will decrease if Rahad takes them. Do you agree?
Yes.
Okay. And Rahad is entitled to use some of the water. Do you agree?
Yes, Your Excellency.
So the water table will decrease necessarily if Rahad even engages in equitable use of the water. Do you agree?
Respectfully, no, Your Excellency, because using 1.2 cubic kilometer of water from the aquifer, which contains 36 cubic kilometer of water, will deplete the aquifer and shortage the water table in the region.
So
And
if we find that the respondent's use was equitable and reasonable, is there then no significant harm?
yes, Your Excellency.
Okay.
Your Excellency, moving to the second submission, the applicant would like to submit two arguments for the second submission. First, Rahat has breached its international obligation to preserve and protect the Ken Canyon complex and mixed heritage. Second, Rahat cannot bring the justifications of necessity and economic development to its destructive project. Your Excellency, moving to the first argument, based on Article 4 and Article 6, Paragraph 3 of the 1972 UNESCO's World Heritage Convention and the preambles of both 1970 UNESCO Convention and 1954 Hague Convention, all states are obliged to preserve and protect natural and cultural heritage situated in their territory and are eloquently prohibited from taking measures that cause them damage, because damage to cultural heritage, which is included in the World Heritage List, is damage to cultural heritage of all mankind, Your Excellency.
Let's focus on Article 6, Paragraph 3. Do you contend that Rahad took deliberate measures to directly damage the complex? Or do you contend that they took measures that indirectly damaged the complex?
Your Excellency, the state of respondent were under an obligation in order to take measures to prevent direct or indirect harms to the complex, Your Excellency.
Yes, so what happened here? What was the harm here?
The harm was the degradation in the remote sections of the complex, and also the degradation in the stronghold within the state of applicant, Your Excellency, and also a pathway in the complex collapsed. Therefore, the complex was banned for the visitors. It is harm to the complex, Your Excellency, as a result of their Savali pipeline operation.
My question is more one of direct or indirect harm, and if there's a legal distinction. As I read the convention, I see direct harm as knocking down part of the canyon to insert a pipeline. And I see indirect harm as a pipeline in the subsurface of the territory that then somehow affected the integrity. So how can Rahad be liable for damage in the convention if the damage was not foreseeable?
Your Excellency, in the case that the damage were unforeseeable, the state of respondent would be without any liability. But the damage to the complex were foreseeable. In paragraph 21, the ELSA reported that as the complex is located near the aquifer, care needs to be taken in order to preserve and protect the cultural site. And also based on paragraph 22.
And what was suggested to be that care? What were they requested to do with their drilling?
The compromise is silent about this, Your Excellency. And also in paragraph 20...
Well, didn't they establish a buffer zone?
Yes, they did, Your Excellency. But, and also based on paragraph 26 of the Act compromise, the state of respondent limited the drilling of water 26 kilometers outside of the buffer zone. But it has nothing to do with the shortage of water table in the region and with the harms which are caused to the complex, Your Excellency, because the harms are as a result of the shortage of water table in the region, and 15 kilometers outside of the buffer zone, or 100 or thousands of meters outside of the buffer zone will nothing to do with the harms to the complex, Your Excellency.
But the ILSA report, Agent, that suggested the buffer zone rendered no opinion about the lowering of the water table and the effect it would have on the canyon.
Your Excellency, the buffer zone was determined before the extraction of water.
No, I understand, Agent, but the question is about foreseeability. If Rahad is liable for direct or indirect harm, shouldn't they have known their action would cause harm to be held liable? Is that a legal requirement?
Pardon me, Your Excellency, can you clarify that?
Does it matter if Rahad knew the harm would occur?
It doesn't matter, Your Excellency.
Right, and so my question is, how would they have known that lowering the water table would cause the harm?
Because the ELSA and as well World Heritage Committee and as well the state of applicant raised their concern about the possible and potential dangers to the complex, Your Excellency. Therefore, they must be aware of the harms to the Canyon complex, Your Excellency. Your Excellency, the state of applicant cannot bring the justifications of necessity and economic development for its destructive project, Your Excellency. Because at first, based on Article 25 of the ILC draft articles on state responsibility for their international wrongful act, states can invoke necessity to preclude the wrongfulness of an act which is not in conformity with international obligation under two conditions. At first, when the action is the only way for the state to safeguard an essential interest, and second, if the action does not seriously impair the essential interests of the states toward the obligation exists. But in our case, at first, there was other ways for the state of respondent in order to have access to water, and as well, not only their action caused harm to the essential interests of the state of applicant, but the whole community, because it caused harm to the Canyon complex, which is included in the World Heritage List in 1994, and therefore they cannot bring the justification of necessity to their destructive measure, Your Excellency. The state of applicant would like to respectfully request this Honorable Court to adjudge and declare that the extraction of water by the state of respondent from the aquifer is inequitable and unreasonable, and the Savali pipeline operation must cease, Your Excellency. Please, the Court.
Thank you, Agent. Maybe I'll stop. When you're ready, Agent.
Good afternoon, Mr. President and Your Excellency. My name is Ramin Mansouri, and I am extremely honored to appear before the International Court of Justice, pleading on behalf of the Federation of Atanya, the applicant in present proceeding. As my co-agent, Mr. Sanglafi, mentioned, I take 21 minutes of this Honorable Court's time, addressing third and fourth submission regarding Rahad's obligation to return the Ruby Cyper to Atanya, its lawful owner, and its failure to receive compensation due to migration of clan kin members to Rahad. Your Excellencies, the applicant will submit two arguments for his third submission. First, Atanya is the lawful owner of the Ruby Cyper, and second, Rahad's returning the position of the Ruby Cyper is in violation of its international obligations. Starting with the first argument, Your Excellencies, Atanya is the lawful owner of the Ruby Cyper under cultural nationalism principle. Under Article 1st of the 1997 UNESCO Convention, which both states are parties to, cultural property refers to property having archaeological or historical importance and belongs to property relating to history and prehistory, Your Excellencies. Moreover, under the cultural nationalism principle, which is accepted in numerous international instruments, including the 1970 and 1972 UNESCO Conventions, cultural properties found within a state's border form that state's cultural property and should remain there. Therefore, Your Excellencies, in 2002, the International Group of Organizers of Large-Scale Excavations stated that the illegal traffic in archaeological, artistic, and ethnic objects must be firmly discouraged. Recently, Your Excellencies, the UN Council in 2347 Security Council resolution stated that asked the member states to provide cooperation in an investigation, prosecution, seizure, and confiscation, as well as the return or restitution or repatriation of trafficked, illicitly exported or imported cultural properties, Your Excellency. In our case,
But how are we to establish that the Ruby Sapar was in fact cultural property protected under this convention?
Your Excellencies, as based the Article 6 of the 1972 UNESCO Convention states that if doesn't matter that if something is added to the World Heritage List or not, it matters if it has a universal value, so it is a cultural property. Secondly, Your Excellencies, Atania in its declaration to the 1970 UNESCO Convention stated that all Atan archaeological objects dating from 1900 CE or before belongs to Atania, Your Excellency. So the facts clearly shows that the Ruby Sapar, as it was belonging, was part of the Atania's territory, part of Atania's territory and history. Therefore, it belongs to the government of Atania, Your Excellency.
I see a different reading of Article 6, Agent. Maybe that's not the right citation, but I would direct Agent's attention to Article 5, paragraph B, that requires a state to have an up-to-date national inventory of property which lists important public and private cultural property whose export would constitute a violation. Your state failed to make such a list, which would be very useful for countries such as the respondent to know what is prohibited. So how can you garner protection under this convention or condemn the respondent if you fail to undertake your obligations under Article 5?
Your Excellency, firstly, the articles, the agents quoted Article 6 of the 1972 UNESCO Convention. Secondly, with respect to concern regarding the listing the Ruby Sapar and national inventory. However, the government of Atania, there is no fact in the compromise to show that the government of Atania has not did so, while we opened a culture center, which the government of respondent was well aware of it, that and we put the Ruby Sapar there in order to the rest of the world could see it. So while more than 300,000 visitors came each year to see something, so it stands to reason that all the world knows that it belongs, it is a cultural property, Your Excellency. Moving forward.
I have a question again about this convention, Agent. Is Rahad bound to the terms of this convention, the specific articles?
Your Excellencies, as Rahat, the respondent may likely claim that, but on the time that the Ruby Sapar was transferred to their territory, they were just a signatory, and they hadn't they were not a party to it. However, being as a signatory based on Article 18 of the Vienna Convention on the Law of Treaties and Article 16 of the Vienna Convention on the Law of Treaties, they were under an obligation to not take any deliberate actions or measures which would be against the aim and purpose of the Convention, Your Excellencies. And we can study the aim and purpose of the Convention from its preamble, as stated in Article 30 and 31 of the Vienna Convention on the Law of Treaties, considering that, Your Excellencies, the aim of the Convention is to stop to prevent the importing illicitly transferred objects and protect the cultural properties around, protect the cultural properties, Your Excellency.
Well, could it be argued by the respondent that while perhaps it was taken to them, they are doing a better job protecting this than your country?
Your Excellencies, there is no fact that we haven't did the thing that they are doing.
Well, I think the first fact, Agent, is that it was stolen from your custody, and so therefore you failed to protect it from Carladugo. Additionally, your country failed to protect the cultural value by locking it away and preventing individuals such as the kin to view it. So we could say that perhaps though it made it to Rahad illicitly, Rahad has respected the spirit of the convention in its protection and display. Could we make such a statement?
Your Excellencies, with all respect, no. Because firstly, the government of Athena was protecting it in a very good manner by opening culture center, and it was a valuable object for our government. That's what more than 300,000 visitors were coming to our country each year. Economically and culturally, it was a best object for us. And Your Excellencies, there is no law around the world that would prove the respondents' claim that to keep illegally or illicitly imported objects in order to claim that, okay, now we can protect this, so we are going to keep. If it would be the thing, so all the powerful countries would collect all cultural objects from all other countries and would say, oh, we can protect it, so we are going to keep it. So what would the original states would do with their cultural property? Don't they have the right to keep their own properties?
That's the question we're here to answer, Agent.
That's the reason that we are here, Excellency.
Okay.
Moving to my second argument, Your Excellency, Rahad's retaining the Cyprus position is in violation of its international obligations. Because, Your Excellency, firstly, Rahad has illegally retained the position. Your Excellency, the acquisition of cultural property must be legal, ethical, and of course, responsible. Furthermore, under Article 2, 3, and 7 of the 1997 UNESCO Convention, its illicit transfer from a state to another is prohibited. Accordingly, source nations are allowed to define illicit by their own. Moreover, Your Excellency, under Article 6 and 13, paragraph D of the 1997 UNESCO Convention, cultural property can only be exported having an export license. Other states, Your Excellency, consequently must enforce the export laws of foreign states.
Your arguments are very convincing, Agent. But for you admitting that they're not bound to the terms of the convention, only the object and purpose. So let me ask you this question. If we find that you failed under Article 5 to list this as a cultural object, can you then, is Rahad then immune from any violations of the object and purpose?
Your Excellencies, they have, if it would be there, yes, but there was nothing, because they just deposited their ratification instruments 3 days before they received the Ruby Cypher in their territory. They deposited the instrument of ratification on 30 September, while they received the Ruby Cypher in their territory on 3rd October, Your Excellency. So, based on Article 18 of the Vienna Conventions, when a state deposits its instrument of ratification, it shows the good faith of the country that they have the intention of acting on what the convention rules says.
What about the respondent's contention that the Ruby Sapar is important to the Kin people as a cultural artifact, as an indigenous people's artifact, and therefore it should remain with the majority of the Kin people? How would you respond to such an argument?
Your Excellencies, firstly, there is no fact in the complaint to show that, well, the Ruby Cypher belongs to clan Kin members. Secondly, Your Excellency, if it would belong to the clan Kin members, so still there are more than 300,000 of them living inside Atania. So what about them? Don't they have right to have access to the cultural property? For sure they have, Your Excellency. Secondly...
So you're asserting the rights of the Kin towards the cultural property?
Pardon me?
You're asserting the Kin's rights in Atania to the cultural value of the Sipar.
Your Excellencies, I said if it would be, so
okay.
they have also the right. However,
because you are not asserting the rights of those same people to have access to water at the same time. So it's curious how you advance that up, but you can move on with your argument.
Thanks, Your Excellency. Moreover, Your Excellencies, the removal of Cypher from public display and Kin's migration cannot justify Rahad's illegal retention of the Ruby Cypher, Your Excellency. Because, firstly, the removal of the Cypher was necessary. Under Article 30 of the ILC draft articles on state responsibility for its internationally wrongful acts, states can invoke necessity for precluding the wrongfulness of an act if the act is the only way to safeguard an essential interest against a grave and imminent peril. Your Excellency.
So could we say that Rahad is safeguarding the essential interests of the cultural property against grave and imminent peril to it in your country. For instance, because of the destruction of replicas, because of the jailing of kin, Sisters of the Sun, and because this particular artifact itself was hidden from public view, that Rahad's actions are, in fact, to protect the value of this cultural property.
Your Excellencies, regarding the jailing of the kin protesters is a matter that the agent would like to discuss it in, for submission, but regarding the protection and hiding it, it was, Your Excellencies, there's under international law and there's no law to state that the states cannot hide or put their cultural properties for out of display. However, they have the obligation to present it. Your Excellency, the government of Atania put the Ruby Cypher involved in order to protect it from the demonstrators, Your Excellency, and it was under a necessary option because the demonstrators using the replicas were provoking disruptive elements within Atanakara. So we consider it necessary, Your Excellency.
So you don't agree with the argument that it was hidden because your government claimed it was a symbol of sedition, but you hid it to protect it. Is that your argument?
Your Excellency, the applicant may, the respondent may likely quote Article 43 of the compromise stating that the government of Atania has stated that the Ruby Cypher is a symbol of sedition. However, there is no wording in the paragraph 43 of the agreed compromise to show that the Ruby Cypher was called symbol of sedition. However, destroying the replicas was due to because the Sisters of the Sun were using it to provoke disruptive elements. And if the government of Atania was willing to destroy the Ruby Cypher, so they had enough time while it was involved. There was a long time that and it was a best chance for the government of Atania to destroy it. However, we didn't.
With your remaining time, Agent, let's advance ourselves to the fourth submission.
Thanks, Your Excellency. Your Excellency, the applicant will submit 3 arguments for his fourth submission. Starting with the first argument, Rahat was obliged to bear the expenses of migrants in his territory under the non-refoulement principle. First, kin members are migrants, for they have intentionally migrated to Rahat. Your Excellency, under Article 12 and 16 of the ICCPR and Article 13, paragraph 2nd of the Universal Declaration of Human Rights and other international instruments, everyone under international law has the right to leave his home country. Moreover, the International Organization of Migrants defines migrant as a person who is moving across an international border. First, regardless of first, the person's legal status. Second, whether the movement is voluntarily or involuntarily. Third, what the causes for the movement are. And fourth, what the length of stay is. Moreover, Your Excellency, the economic migrants leave home voluntarily to take advantage of better opportunities in other countries.
So are you claiming these are economic migrants?
For sure, Your Excellency.
What is the evidence in the compromise that they did so under the motivation to take advantage of economic opportunities in Rahat?
Your Excellencies, out of 800,000 people who left their country and migrated to Rahat, 645,000 of them claimed because they left due to starvation and lack of having access to water and food, which was the main reason of it was extraction of water by the government of respondent, Your Excellency.
But that doesn't make them economic migrants.
Your Excellencies, and
it sounds to me that you said they're leaving because they're starving, not because they have a better opportunity. I mean, they necessarily have a better opportunity because they're starving. Let's focus ourselves on the Refugee Convention and how we define refugee. What is the legal standard to define refugee?
Your Excellencies, based on Article 1st of the 1951 Convention, refugees are a person who are owing to well-founded fear of being persecuted for reasons of membership of a particular social group or political opinion, is outside the country of his nationality, or is unwilling to avail himself to the protection of that country. However, Your Excellencies, based on the facts of the compromise, the clan members, they are first member of a member of a group and member of a group, Your Excellency, and belongs to different ethnic or religious. But there was no well-founded founded persecution against them by the government of Atania. They left their own country by their own free will, using their own free fundamental right of migration, Your Excellency.
Can't we, I suspect the respondent will argue that the RAP Act was a law that persecuted the kin. How can you respond that it was not?
Your Excellencies, the government of Atana enacted the RAP Act as the facts in the complaint, mostly the paragraph 33 and 34, clearly shows that the government of Atana enacted the RAP Act due to Rahat's overutilization of water from the aquifer, which caused water shortage in the region, and consequently 20% of Atana farmlands could no longer be farmed due to Rahat's implementation of the Savali pipeline project. The government of Atania, in order to limit the utilization of water, by the people, enforced them to enacted a law in order to ban license, Your Excellency, which were covering all the citizens of Atania.
But the licenses were not required for the larger farms.
Yes, Your Excellency.
And the larger farms presumably use more water.
Yes, Your Excellency. Because
so is it a sort of against our common sense and logic that you would give exemptions to the large farms that use more water but yet require subsistence farmers nonetheless to have licenses?
Your Excellencies, it belongs to the national policies of the government, which is a common thing around the world. The large farmers were producing already more than 75,000 USD dollar each year. So they were in a way or another helping the government economically. So how the
much like Rahad's extraction of water was helping their economy, and yet your co-agent is saying that was not an allowable use for the water.
Your Excellency, the government of that was an issue. The Rahad's implementation of Savali pipeline was is another issue which was discussed by my co-agent. However, I would like shortly say that they were utilizing water by causing harm to their neighboring states, Your Excellency. But in our case, our people were helping us to grow our economy. Since we were facing economic bankruptcy in our country, not the government of respondent.
So instead of denying water to those who don't get permits, wouldn't there be better administrative mechanisms like a fine or some other type of penalty instead of just cutting off water?
Your Excellencies, based on paragraph 35 and 36 of the agreed compromise, firstly, there were people who violated the laws by not purchasing license, and they are using water over quota. The government distributed layers across all the farms, and in order to be asking them to stop over-utilizing water. But they didn't do that, and instead overutilized water and acted against the laws. So for sure, it's a common thing around the world that when people act against the law, they will be charged and they will be imprisoned.
But if your co-agent is claiming a right to water, that individuals under the ICESCR or the UN Declaration of Human Rights are entitled to water, is your denying these kin that water by cutting them off itself a violation, even though it's legal under your domestic law, that it fails your international obligations?
Your Excellencies, for sure the government of Atana had an obligation to provide water for all of its citizens. However, we are fulfilling our obligation by importing water in drought conditions at the great expense from other countries. And we had no alternative except of cutting water to those farms who violated the law.
Let me ask you a question since you're almost out of time. If we disagree and find that these are refugees, what is your best argument to why you don't have to pay compensation?
Your Excellency, even if the court considers that the kin members are refugees, not migrants, the applicant submits a second argument that the HOT's claim for compensation is unprecedented under and autonomy owes no compensation. Your Excellency, there is no positive law and international law, whether judicial decisions, conventional laws, or customary international law, as I see my time is over.
You can finish your statement.
There is no positive law to prove their claim, and nor there is a precedent and around the world to prove their claim regarding the compensation. Therefore, they have no permissive law and they cannot ask compensation.
Thank you, Agent.
It's a lot. May I please go?
We are pleased. Agent for the respondent, when you're ready.
Good afternoon. Mr. President, Your Excellency, may it please the Court. My name is Connor Brightwell, and I have the honor to appear on behalf of the Kingdom of Rahat, the respondent in today's proceedings. I will speak for 22 minutes, and Matthew Schreiber, my co-agent, will speak for 22 minutes. At this time, we respectfully request that 1 minute be reserved for rebuttal. Your Excellencies, over the course of 22 minutes, I will submit that Rahat's extraction of water from the Greater Inada Aquifer did not violate any international principles related to the shared use of a transboundary resource. Next, I will submit that the Rahat-Savali pipeline operations did not violate any international legal obligations relating to the King Canyon complex. My co-agent will demonstrate that the Ruby Sapar should remain in Rahat, and the Rahat is entitled to compensation for hosting Atanian refugees. Your Excellencies, we have heard from counsel for the applicants that Rahat's extraction of water from the aquifer violates international legal obligations because it created a binding unilateral declaration and violated the principle of no significant harm. However, this is not the case, for two reasons. First, that Rahat has no binding legal obligations relating to use of the Inada Aquifer. And second, even if it did have binding obligations, its use is permitted under the draft articles on transboundary aquifers and specifically related to the principle of no significant harm of international environmental law. Moving to the first subpoint, that Rahat has no binding legal obligations relating to use of the Inada Aquifer. Pursuant to ICJ Statute Article 38(1)A, this court can consider such things as conventions or other binding agreements in judging the dispute between two parties.
Well, Agent, let's talk about binding unilateral declarations. The applicant claims that the water minister was a party who was able to bind your government in the statements. Can you address that point specifically in terms of this minister and their ability to bind?
Yes, Your Excellency, and the Rahati Minister of Water and Agriculture could not bind the state of Rahat to a binding unilateral declaration for two reasons. First, that he did not have the specific authority to be able to make such a declaration, and second, that even if he had such authority, his particular statement, as made in complementing paragraph 16, was not sufficient to show a requisite intent to be bound by the state to form a binding unilateral declaration. And since the Peace of Westphalia has been recognized that very few individuals do or should be able to have the authority to bind the states, and the UN guiding principles applicable to the unilateral declaration of states indicates that only a head of state or government or a minister of foreign affairs has the implicit authority to bind a state. It is true that these guiding principles recognize that it is possible, given the right set of circumstances, that an internal minister could bind a state. However, we do not have those right set of circumstances here. Specifically in paragraph 48 of the case concerning armed activity in the territory of the Congo, between the Congo and Rwanda, this court held that the statements that the few instruments not yet ratified will shortly be ratified, and past reservations not yet withdrawn will shortly be withdrawn, was insufficiently specific to be binding. And this was despite the fact that this internal minister for Rwanda was speaking in context of the Geneva Convention. And as indicated in paragraph 554 of the frontier dispute between Mali and Burkina Faso, when a better method to come to a binding agreement is practicable under the circumstances, that must be the way that two countries come to a binding resolution to a dispute. And that was despite the fact that the Mali head of state did have the requisite authority to be able to make a binding unilateral declaration. Here, with the specific facts at hand, the Rohani minister was in Atanagrad, accompanied by the Queen Teresa, who had every authority to make such a declaration. However, despite these circumstances, the Queen did not make a declaration that could have bound the states, and it was indeed practicable under the circumstances to seek an alternative means of coming to an agreement, such as a contract or other written document.
But can't we say that there was, the authority was endorsed by the Queen, who had implicit authority since she was present?
Respectfully, no, Your Excellency, because with the standard set with the case of Mali and between Mali and Burkina Faso and the frontier disputes, even if the Queen had ratified that contract to make a binding declaration, it still would have had to have been the best means available under the circumstances. However, even if it was the best means available under the circumstances, looking to the specific facts of this case, it would still be insufficient to show a ratification of that conduct, because the statement was not sufficiently specific to create a binding obligation. It was merely a representation of goodwill and cooperation to come to an agreement in the future related to the shared use of this resource.
Well, if we find that there was actually an obligation, the agent for the applicant said that your use was not equitable and reasonable. How can you address that claim?
Your Excellency, assuming that you were to find that the statement by the Rouhani minister binds Rahad to theories of reasonable and equitable use, it has still met these standards under international law, and specifically looking to the draft articles of the ILC on transboundary aquifers as a source of guidance rather than a source of binding law. It shows through Articles 4 and 5 that Rahad's use is consistent with the theory of reasonable and equitable use.
So let me ask you there, do you disagree with your opposing agent that this is a codification of customary international law?
Yes, Your Excellency, specifically because customary international law requires two elements, opinion juris and state practice. And opinion juris requires that states indicate that they believe a certain principle to be binding upon them, to be legally binding, and not merely a representation of good faith. And here the ILC draft articles were passed without vote in 2011, not indicating that any members of the UN General Assembly thought them to be binding. And further, many of the provisions of the draft articles come from the UN Watercourses Convention of 1997. And to date, only recently have 35 parties agreed to this provision so that the agreement could even come into force, and this is out of almost 200 parties. And indeed, there was a dispute because of this particular weight that was given to the principle of no significant harm. And as such, this does not represent customary international law. And while a few states, such as with the Al-Qasag, Al-Disi Aquifer, have implemented the agreement, and the Guarani Aquifer Agreement has suggested the draft articles should be binding, there is insufficient state practice to suggest customary international harm.
Okay, but if we do accept the argument that it is, how then can this be equitable and reasonable if your country is using it for purposes, as the applicant suggests, economic uses for your gas industry and for your farming operations?
Specifically, Mr. President, Article 5 of the draft articles enumerates a list of factors that form a totality of the circumstances analysis in determining whether use is reasonable and equitable. And some of the most important provisions that are indicated are the geological characteristics of the water and the human needs at stake. The geological characteristics of the aquifer, And looking particularly to this aquifer, the Greater Nod Aquifer, the company indicates that 2/3 is located under the territory of Rahad, indicating that as a matter of equity and division of this resource, it should at least be guiding that 2/3 of the aquifer is within the control of Rahad. And indeed, my opposing counsel has conceded this point, that Article 3 of the draft articles gives sovereignty for the state of Rahad to the area of the aquifer within its control. And specifically looking to the human rights issues at play, Rahad is using the water primarily to preserve essential human rights. And it is true, Your Excellency, that some of the water is going to the oil industry. However, the majority is going to protecting the agricultural industry, which, as indicated in compromise paragraphs 2 and 3, is the primary means of sustenance for the state of Rahad. And as opposed to the state of Atania, which exports much of its agriculture, the agriculture within the state of Rahad has no appreciable exportation, is going primarily to feeding the citizens of Rahad, and indeed the refugees that have now come from Atania as a result of the RAP Act. And
what about, the obligation to cooperate found in Article 7 of these draft articles? If we find that indeed this is a codification of customary international law and binding on your country, have you done anything to meet your obligation under Article 7?
Yes, Your Excellency, and specifically the duty to cooperate in international law, and as contemplated in these draft articles, is a narrow duty which requires both notification and, in certain situations, negotiation. And indicated in GA Resolution 2995 and the Rio Declaration, as well as the Watercourses Convention and these draft articles, the primary purpose of notice is to put a country on notice, for lack of a better word, to give them the information needed to know that a country is going to take a particular action. And here Rahad has provided the specific notice through, over the course of many years, indicating that it intended to use the Somali pipeline and through conducting a series of tests to find the best use of that pipeline. And while negotiations are in certain circumstances a necessity under international law, under these specific draft articles, it is recognized that negotiations are necessary only when international peace or security is at stake. And no facts in the compromise indicate that that is a consideration at play here.
What about Article 7.2 that says aquifer states should establish joint mechanisms for cooperation? Were any joint mechanisms established here?
No joint mechanisms were established. However, as that provision indicates, that it would have to be a mechanism formed by both countries. As indicated in compromise paragraph 23, with the mere suggestion that Rahad intended to use water from the aquifer, as indeed Atani had been doing for many years, President Van suggested that Queen Teresa should cease her activities to utilize the aquifer altogether. Irrespective of stating that they should use it to a particular degree, they didn't want her to use it at all. And they showed a lack of receptiveness even to coming to a joint mechanism to establish and protect this resource. And for that reason, cannot argue that cooperation in this sense is at issue here. And further, counsel for the applicant has suggested that Rahad has breached the obligation to not cause significant harm. However, the no significant harm rule of international environmental law is very narrow and is not applicable here. And this rule stems from the Roman Latin doctrine, secutare tuo ut elenum non litis, and looking specifically to previous instances of where it's been contemplated at international law. In the United Nations Economic Commission, Convention on the Protection and Use of Transboundary Watercourses in International Lakes, it recognized that the no significant harm rule is a duty not to cause damage through pollution to transboundary water resources. And further, in the Trail Smelter arbitration at page 1965, it recognized and stated that no state has a right to use or permit the use of its territory in a manner such as to cause injury by fumes, not to cause injury by subsidence, and something like subsidence or lowering of a water table is not within the scope as envisioned in the no significant harm rule. And this notion is reaffirmed by the text of Article 6 of the draft articles, which contains no overwhelming prohibition on significant harm. It rather states that appropriate measures should be taken to avoid it. And such measures have been taken here by Rahad through moving its operations beyond the buffer zone established at the time of listing and indeed 15 kilometers away from the site. And further,
You claimed, Agent, that the applicant is using the water from the aquifer, but they're not taking any positive measures to drain the greater Nunavut aquifer. In what way are you claiming that they're using the water similarly to how you're doing it?
in the past, they have relied on natural outflow from the aquifer, which is something that is indicated in the compromise Rahad has not had the luxury of. However, since Atini's argument stems around the fact and states that because this natural outflow is no longer available, Rahad has caused significant harm to Atania. However, Rahad has done nothing that prohibits Atania from taking similar measures to utilize this aquifer. But their argument suggests that they should have to undergo no financial burden, no burden of labor to be able to utilize this resource. And especially in light of the human rights obligations which Rahad is entitled and obligated to represent and protect under the ICSER and the ICCPR, this argument cannot stand. And further, as it relates to no significant harm, a provision that would ban irreversible harm was intentionally omitted from the draft articles as indicated in document ACN 4591 of the 5th Report on Shared Natural Resources. And Chusei Yamada, former Special Rapporteur on Transboundary Resources, a member of the IOC, whose authority can be relied on pursuant to ICJ Statute 38(1)D, has indicated that principles of sustainable development cannot be applied to a recharging aquifer system, and further stated that the intent of Article 6 was to protect aquifers from the heightened risk of pollution due to their particular geological nature and not to subsidence that would be inevitable given a non-recharging resource.
Okay, Agent, let's say that we agree with you on the notion of significant harm to the aquifer. you did cause significant harm to the King Canyon complex by the drilling of the aquifer. Do you deny that that occurred?
Rahad does recognize that harm did occur to the complex, and if I may, Your Excellency, I'll take this opportunity to transition into issue 2 and submission 2 by Rahad, which is that Rahad has met all obligations imposed by the 1972 World Heritage Convention to protect World Heritage. Counsel for the applicant suggested that Rahad has not met its duties to protect cultural heritage and natural heritage. However, it has through the affirmative measures it took to protect the King Canyon complex, irrespective of the harm that ultimately occurred. Looking specifically to compromise paragraphs 25 through 27, before even undergoing any Somali pipeline operations, Rahad commissioned an ILSA study to find the risk of harm that might occur to the King Canyon complex if the Somali pipeline was implemented. And this would be meeting its obligations imposed by Article 4 of the WHC to protect natural and cultural heritage.
Now, applicant points out that the report noted with concern potential issues regarding possible subsidence of lands. Did that create any burden upon you to take different action?
No, Your Excellency, for one particular reason. This was recognized by the World Heritage Committee, who Rahad submitted its report to pursuant to Article 11 of the World Heritage Convention, and it did recognize there was a risk of subsidence. However, the risk of subsidence, as indicated in clarifications to the compromise number 1, was to areas superadjacent to the aquifer. And areas superadjacent to the aquifer do not include the King Canyon complex. The ILSA report recognized that there could be a risk of harm to the complex, but only if it were due to proximity of drilling operations to that complex. And recognizing that there was a risk if drilling operations were too close to the complex, Rahad undertook to move all operations beyond the 2-kilometer buffer zone established jointly at the time of listing under the convention, and a full 15 kilometers away from any World Heritage site.
Did you have an obligation to stop drilling once damage occurred to the complex?
No, Your Excellency. What the World Heritage Convention specifically imposes is when, despite the good faith efforts of a state to reduce and ameliorate significant harm, is unsuccessful, that a country should submit to the World Heritage Committee to determine the best course of action. And clarification to the compromise number 6 indicates that Rahad did exactly that. Upon recognizing through a report by an independent panel of geologists in 2010, and recognizing that harm had occurred and could be attributed to the Somali pipeline, Rahad met with the World Heritage Committee, whose recommendation was that Rahad establish a series of targets, and that they utilize these targets in order to rectify the damage that had occurred and to make sure that damage would not occur in the future. And compliance with this recommendation of the World Heritage Committee is the obligation of Rahad under the convention, and Rahad has therefore met all obligations imposed by the convention. And on rebuttal, counsel for the applicant may argue that the World Heritage Committee's authority would not be binding in this circumstance. However, given the particular nature of the World Heritage Committee, its authority should be given significant weight here, and the recommendation should be given significant weight. Looking to the operational guidelines, paragraph 132 of the World Heritage Convention, as well as looking to the specific actions that Rahad has undertaken under the World Heritage Convention, Rahad's affirmative actions to comply with the decision of the World Heritage Committee, both before even implementing the Somali pipeline, then after damage occurred in finding a way to ameliorate the damage, is consistent with the specific recommendations of the World Heritage Convention under Article 7. And further, Rahad has undertook an environmental impact assessment in compliance with its investigations and attached that environmental impact assessment to the report which is sent to the World Heritage Committee, and has further undergone many steps above and beyond what could be imposed even by the World Heritage Committee, and has met the obligations under customary international law to protect natural and cultural heritage.
If the Heritage Committee finds that further damage may occur as a result of drilling, are you then responsible to stop drilling? If
the recommendation of the World Heritage Committee is that the best course of action is to cease, either permanently or temporarily to assess the risk of harm, then Rahad would be bound by that statement and that recommendation. However, such has not occurred here, and without such a recommendation by the World Heritage Committee, there's no indication that Rahad has not otherwise met the duties imposed upon it under the convention. And as a second point, counsel for the applicant argued that the theory of economic necessity could not be argued in relation to the World Heritage Convention. However, this is not the case. And even despite the good faith efforts of Rahad, if Your Excellencies were to find that Rahad had otherwise violated the World Heritage Convention, Rahad's use is justified under the theory of economic necessity. Looking specifically to GA resolution commended to the draft articles and responsibility of states for internationally wrongful acts, 2001 resolution 5683, it recognized that certain acts are internationally wrongful and would subject a country to liability, a state to liability, unless they had a defense under those acts. And specifically, one of the available defenses is that of economic necessity. And to claim necessity, the draft articles at Article 25 require two elements. First, it requires that there be an essential interest safeguarded by the claim of necessity. In the Gabchikovu Nachimaro's case, an environmental interest to be protected in the interests of the extension of the Danube River was sufficient to be deemed an essential interest.
Well, here we have not an environmental interest, but a human rights interest in the need for Atania to supply water to their farmers. Can you still claim that an economic interest will outweigh the need for water for human rights purposes?
This economic necessity would also extend to the efforts by a state to preserve both its people and its means of accessing an economic resource to the degree necessary to maintain its economy. And as a point of clarification, Your Excellency, applicant is incorrect to state that Atania, if they were to state that Atania has not been able to provide water to its citizens. As indicated in the compromise, they have taken the affirmative measures necessary to provide water to their citizens.
So why has your country not imported water?
Specifically because, on looking to the theory of economic necessity, Articles 2 and 3 of the compromise indicate that the GDP of Rahad is much smaller than that of Atania. And given the series of droughts which have required Rahad to import water in the past, Rahad is no longer able to undertake that burden in the same way Atania is, because it does not have the same resources available or at its disposal. And looking to the second requirement, I see my time is ending. May I briefly conclude?
You can sit down. Amy.
Okay, thank you.
You may proceed when you're ready.
Good afternoon, Mr. President, Your Excellency, may it please the Court. My name is Matthew Schreiber, and I have the honor of appearing on behalf of the Kingdom of Rahad, the respondent in today's proceedings. For the following 22 minutes, I will be submitting that the Ruby Sapar should remain in Rahad, and that Rahad is entitled to the requested compensation for hosting kin refugees. Moving to the third submission, the Ruby Sapar should remain in Rahad, because it is an item of cultural importance to the kin people and not Atania, and Atania has not adhered to its international obligations for the following three reasons. First, the Ruby Sapar is not legally protected by the 1970 UNESCO Convention because Atania has failed to follow proper procedure. Second, Rahad had not yet ratified the 1970 UNESCO Convention when the Ruby Sapar entered Rahad, and therefore has no legal obligation to return it. And third, the Ruby Sapar is an item of cultural importance to the kin people and not to Atania as a whole, and therefore should remain with the vast majority of kin people in Rahad and remain in Rahad indefinitely. Moving to the first point, Atania has failed to follow proper procedures set forth by the 1970 UNESCO Convention, and therefore should not be allowed to garner the protection of the Convention. Article 5 dictates that states must create legislation and regulations to protect items, create an inventory of the recognized items, and establish rules pertaining to the ethical aspects of the Convention. Article 6 dictates that states publicize prohibition of illicit transportation. And Article 7 dictates that states take any other necessary measures to ensure that institutions don't allow for illicit transportation of protected items.
But here we have cultural property that is so obviously important, and of an artifact that's not only obviously important to them, but also to your country as well as it relates to its history. Is there any provision about the obvious nature of this piece of artifact that can supersede the requirements?
There is no provision that states simply because an artifact is so well known that it should be allowed to be protected without the proper procedure of the convention. Rahad does not contend that the Ruby Sapar is not a culturally important item. However, it is Rahad's contention that because Atania has failed to follow any of the procedures set forth by the 1970 convention and has taken no steps other than placing the Ruby Sapar in a cultural center, should it be allowed to garner the protection of the convention. Furthermore, the 30th General Conference of UNESCO adopted the object ID as the proper standard to be used when recognizing items as culturally important. This standard sets forth 9 identifying features that a state will catalog when including an item as culturally important and attempting to garner the protection of said item. And while that is not a binding document, UNESCO has identified this as the standard and the best practice for which states should use when identifying culturally important items. In the case of the Ruby Sapar, it is a well-known item to both Atania and Rahad and is a recognized culturally significant item. However, Atania has taken none of the steps set forth in either the UNESCO conference or the object ID.
Well, the applicant says that they have displayed this in a museum, that it has been a source of great tourism activity in their country as a result, and they did make a general declaration. So from a matter of policy, wouldn't it undermine this convention entirely if, because of these deficiencies on the part of the applicant, it would still allow for cultural property to be stolen and removed?
It would not go against the policy of this convention to allow for the Ruby Sapar to remain in Rahad. Firstly, because Rahad and Atania both have historical ownership rights of the Ruby Sapar, and it is culturally important to both the people of Rahad and the people of Atania, as well as the kin people, and most importantly to the kin people. And because the Ruby Sapar was discovered in land that was originally co-owned by both the inhabitants of Rahad and Atania, there is no policy reason to suggest that simply because Atania did not follow these steps, they should be allowed to garner protection of the item simply because they had taken steps to put it in a center. That does not comport with the requirements set forth in Articles 5 through 7, nor does it comport with the structure or purpose of the object ID, which was adopted by UNESCO as the best practice and the standard.
So let me ask you this. Do you agree with the applicant that you are bound by the object and purpose of this convention?
Yes, as a signatory, when the final instrument of ratification was deposited on the 30th of September, until the 30th of December 2014, Rahad was bound by the object and purpose of the convention.
And what is the object and purpose of the convention?
The object and purpose of the convention can be garnered when reading Article 31 and Articles 18 and 31 of the VCLT, and the object and purpose should be understood when the text of the convention is read in conjunction with the preamble. And in this case, when reading both the preamble and the text together as one whole document, the object and purpose of the 1970 convention should be to protect items of cultural importance. In the case of the Ruby Sapar, that is exactly what Rahad is doing. It was clear that Atania was unable to protect it to the extent that it should, considering it was stolen from their state fairly easily and brought into Rahad with the flow of refugees. And Rahad has now taken possession of it and is protecting it to the best of their ability and will indefinitely protect it and allow for it to be on public display for both the citizens of Rahad and the citizens of Atania.
The applicant claims that the object and purpose of this is to prevent illegal import and export and transfer of cultural property, which indeed is the title of this convention. Why should that not be the object and purpose?
Applicant has indicated this should be the object and purpose because the VCLT states that the object and purpose comes solely from the preamble. However, Article 31 of the VCLT, which this court may rely upon pursuant to the statute of the ICJ, Article 38(1)D, Article 31 dictates that the object and purpose should be understood when both the text and the preamble are read in conjunction. And in this case, when reading the text with the preamble, it's clear that the purpose of the convention is to protect these items from damage, from transportation, from theft, a number of things. It is not solely to prevent illicit transportation of items, it is to protect these items and allow for them to remain culturally important and not be destroyed or go dark if they were stolen by another nation.
If we disagree with you, but agree with the applicant on the object and purpose, do you then lose this argument?
No, there's no reason that Rahad would lose this argument if the object and purpose were to be determined as what applicant has stated, because Rahad as a nation played no part in the removal of the Ruby Sapar from Atania and simply retained possession of it when it was also dealing with the massive influx of kin refugees. It took possession of the Ruby Sapar because of the turmoil in Atania. It deemed that to be the best and most proper way to protect the Ruby Sapar, and Rahad has now taken steps to place it on display and taken other necessary steps to ensure that the purpose of the convention, which is protecting these items, will always be upheld, and the item will be on display for both citizens of Rahad and Atania.
Let's talk about those refugees. Your third submission is that this belongs with the kin because it's important to the kin.
Yes.
Why, as the agent for the applicant suggested, why then are we going to deny the kin in Atania from the rights to this Sipar?
It is not denying the rights of any of the kin people if the Ruby Sapar remains in Rahad. Rahad and Atania being neighboring countries sharing this aquifer and originated from the same large country, it is very easy for these kin people that remain in Atania, if they do stay there indefinitely, it is easy for them to go to Rahad and see the Ruby Sapar on public display. Furthermore, there is a strong likelihood that the kin people remaining in Atania will migrate as refugees, will leave Atania as refugees and flee to Rahad due to the ongoing water crisis and the direct actions taken by the Atanian government to withhold water from the kin people. The Rahadian government has shown that they will provide the kin people to the best of their ability with water, food, housing, and in the case of Atania, the Atanian government is directly withholding water from only the kin people.
We will address that point, agent. But what if the kin, however unlikely, leave Rahad and say come to the United States as refugees? Then should the Sipar follow them, as it is culturally important to them?
The Ruby Sapar should not follow them wherever the kin people may travel to following this ongoing crisis. The Ruby Sapar should remain in Rahad indefinitely because Rahad has shown that it can protect the Ruby Sapar and is protecting the Ruby Sapar to the best of its abilities, and allowing for the item to travel wherever some percentage of the kin people go would not allow for the 1970 UNESCO Convention to be upheld in any sort of regulated way, in the fact that you would have to come to some bright line determination of what percentage the kin people have to leave to allow for the travel of the Ruby Sapar. In the case of Rahad, Rahad is protecting it. It is currently housing numerous kin people, and as a neighbor of Atania, in the sense that the kin people will eventually return to Atania because they are refugees, Rahad is a neighboring nation and will protect the Ruby Sapar and continue to protect the Ruby Sapar and display it so that the kin people will be able to visit it and pay their respects at any time that they please. And solely because the kin people might potentially flee or travel to another nation in no way means that the Ruby Sapar should leave Rahad and travel with the kin people.
Do you have any examples, international law or practice, of if we find this was stolen, failure to return stolen property?
There are numerous examples in which a nation has stolen the property of another and failed to return it. The most well-known example is the Elgin marbles, which remain with the British despite numerous requests from the Greek to return them, and these are marbles stolen from the Parthenon. Furthermore, there is also a bust of Nefertiti that has remained in Berlin's Egyptian Museum despite numerous requests from the Egyptian Supreme Council of Antiquities. Also, Priam's treasure was discovered by German archaeologists and later stolen by the Soviets, and continues to remain in Russia despite numerous requests from German authorities. Now, all of these items were stolen during wartime. However, there are no well-documented examples of items being stolen in peaceful times, such as what has occurred here. However, because the examples all come from wartime, this court should look to these examples and see that although there is opinio juris that says these items should be returned, there is not a well-practiced or well-founded state practice that these items actually are returned. So this has not risen to the level of customary international law to force Rahad or impose any legal obligation on Rahad to return the ruby sapphire simply because it has retained possession of it when it was stolen from Atania.
With the balance of your time, Agent, let's address the refugee issue.
Yes.
The applicant agents suggest that these are in fact not refugees, but migrants under several legal definitions that they provide. Why then are these not migrants, but yet refugees?
These are not migrants because, as applicant has stated, the 1951 Convention related to the status of refugees defines a refugee as a person or persons fleeing their country of origin due to a well-founded fear of persecution. The UN Refugee Agency Handbook does define what a well-founded fear of persecution should be understood to be as in Section 42, and states that an applicant's fear should be considered well-founded if he can establish to a reasonable degree that his continued stay in his country of origin has become intolerable to him or would be intolerable if he returned. In the case of the Kin people, their stay in Atania had become intolerable and would be intolerable if they returned due to the direct actions taken by the Atanian government through the implementation of the RAP Act. Now, the RAP Act does not directly target or discriminate the Kin people solely on its face. However, there are strong discriminatory effects that only affect the Kin people, and the European Court of Human Rights in SS versus France found that when a law has discriminatory effects against a certain specific group of people, as this was a ban on burqas, that the only way the law can be upheld is if it is shown in every instance and when the law is said to be violated, there is a reason for state protection. In this case, there is no reason for state protection that would allow for the complete withholding of water from all of the Kin people, which, as stated by the International Federation of the Red Cross, has resulted in 500,000 cases of malnutrition and widespread food deprivation related illnesses.
But this is very different. The case you cite involved a complete ban on religious clothing. Here, the Kin have a means to get the water that they need through a regulatory scheme that they chose not to follow. Isn't that slightly different?
That is not slightly different because in this case, the Kin people did not choose not to follow this regulation that was allowed for them. They were unable to follow it due to their religious convictions. They did not believe, or the Kin people hold a belief that they should not and will not ask the government for assistance when using the planet's natural resources. In this case, according to the RAP Act, the only way that the Kin people would legally be allowed to use the water is if they went to the government to request a license, which, aside from the religious problems, also was heavily in favor of larger farms and farms that were producing much more money than any Kin farms were, which were used solely for independent use.
What about the applicant's contention that the RAP Act was only put into place because of your nation's drilling activity that caused harm to their ability to farm and their ability to access water through the natural outflows? If we agree with them that you, in fact, caused this situation, could these still be refugees?
Yes, these still could be refugees because if this court were to find that the implementation of the RAP Act was necessary due to the actions of Rahad, the newly amended RAP Act is what really is at question here. And the newly amended RAP Act states that if you refuse to abide by the regulations set forth, you will be deprived of water. And in this case, the Kin people were, as stated, unable to abide by the rules set forth in the RAP Act because of their religious convictions, and they were unable to abide by these rules due to financial reasons. So regardless of whether the initial RAP Act is deemed to be the fault of Rahad or Atania, the newly amended RAP Act, which deprives water and deprived water solely from the Kin people, is in no way the fault of Atania, or the fault of Rahad, excuse me. Atania had much simpler and more feasible means to implement punishment for not following the RAP Act that would not have resulted in human rights violations, which is what has occurred here. The withholding of water has violated both the ICESCR and the ICCPR, both of which indicate a right to life, and comments to which have indicated that these right to life include a right to water and a right to nutrition and to be free from malnutrition, none of which has occurred in Atania. The Atanian government's implementation of the newly amended RAP Act has directly deprived these people of water, and in regards to the kin people, this has resulted in a deprival of the right to life, because this water was their sole means of providing food for themselves and their families, and without this water, there has been widespread malnutrition and widespread food deprivation related illnesses.
Well, Agent, let's say we agree with you that these are refugees. The agent for the applicant has stated that there is no positive law obligation upon them that would compel them to pay your country, as you're seeking, for these refugees. How can you overcome that legal hurdle?
There is no case law that suggests that or dictates that countries of origin do have to pay the costs of refugees that have fled. However, the refugee crisis has been growing exponentially in the world in the past decade or decade and a half, and recently the UN has begun to recognize this problem and has begun to make statements suggesting that countries of origin should be forced to pay at least some sort of compensation. In 2012, the UN General Assembly re-emphasized the fact that reducing and preventing the creation of refugees is primarily the responsibility of the states. And Volker Turk also stated that every minute there are 24 people being displaced now, and it is time to move beyond the status quo and find approaches to the refugee crisis that go beyond business as usual. Furthermore, in 2016, the Secretary General of the UN at the 70th session stated that the massive amount of refugees throughout the world is a serious issue, but is not insurmountable if states act together and share responsibility more equitably.
Well, that's sharing responsibility. Here you're asking Atania itself to bear the burden of the responsibility. How can we take these statements that you're claiming and force them to pay?
It is Rahad's contention that Atania should face the brunt of the responsibility for paying this requested compensation, because the reason that the refugees were forced to flee Atania was because of a direct action taken by the government when there was many other options available. However, if this court were to require that Atania pay a portion of the compensation, that would also be a good result for Rahad. And this is so because while the UN has re-emphasized that other member states should be forced to pay to ease the effects of refugee crises, in the past, or in 2012-2015, in regards to the Syrian ongoing refugee crisis, it was shown that Lebanon had a shortfall of approximately $870 million US. Turkey had only 60% of its needs met, Egypt had only 45% of its needs met, and Jordan had only 60% of its needs met. All of this money was coming from other member states that were helping to compensate for the influx of people in these nations. However, it is clear that this member state contribution is not enough, and in the case of the actions taken by the Atanian government, where it was the implementation of a law that directly affected a sole group of people that were then forced to flee or forced to die of starvation in their host nation, or in their country of origin, the Atanian government should be forced to pay the full requested compensation, at the very least a portion of the compensation that was requested, because it is clear that the compensation from member states is not enough, and the ongoing refugee crisis that is increasing every day in this world needs to be addressed in a more proactive way. And this
So why is it not better for an optional protocol to the Refugee Convention or a special session of the General Assembly to adopt a rule, or even the Security Council? Why should this court undertake a traditional legislative action to create this binding obligation on Atania?
What you proposed would be the ideal situation. However, this court has the opportunity today, pursuant to the statute of the ICJ, Article 36, to fill a gap in the refugee conventions. The refugee conventions neither prohibit or allow for compensation to be paid by countries of origin, and that is a gap in this law that this court has the ability to fill pursuant to Article 36. And it should take the opportunity now to fill this and to at least require that countries of origin pay some of the requested compensation. Not only would this create incentive for countries to not produce refugees, but it would also create more incentive for countries to do everything they can to prevent human rights violations happening, such as here. If this were the rule moving forward and this situation were to happen, the Italian government likely would not have amended the RAP Act in such a way that deprived 800,000 people of water. And furthermore, if this court declines to extend the convention, this was also an internationally wrongful act for which it owes the requested compensation pursuant to the 2001 draft articles for the state's responsibility for internationally wrongful acts.
You're just about out of time, Agent, so we'll read your brief submission on that.
Okay. Did you want me
No, sit
to?
down.
Okay.
Okay. And we'll take a rebuttal from the applicant when you're ready. Delicious.
Please the court. Your Excellency, the applicant would like to point just to 2 points which are regarding the misuse of the rules and misuse of the facts by the state of respondent. The first point, the agent for the respondent argued that the Minister of Water and Agriculture of the state of respondent was not authorized to bind its country, but the court should be mindful of Article 4 of the ILC draft articles and also its decisions in the nuclear test case in paragraph 46, Your Excellency. However, the declaration was made by the Minister of Defense, but the court found that this declaration is obligatory for the France, Your Excellency. The second point, the agent for the respondent argued that the complex is not superjacent to the aquifer. We do accept that the complex is not superjacent to the aquifer, but if you refer to paragraph 21 of the Agreed Compromise, ELSA, a Rohadi government funded institution, which is one of the state of respondent, reported that because the complex is near the aquifer, care should be need to be taken in order to preserve the cultural and natural heritage. Your Excellencies, as a last point, the agent for respondent argued that there is no state practice regarding the restitution in peacetime, but the applicant would like to address the case regarding between Turkey and Metropolitan Museum of Art, where Lydian artifacts were returned to Turkey after the Met admitted that the objects were stolen when they had purchased them, Your Excellency. May it please the court?
No talking, Agent.
May it please the court to address the points made in rebuttal by the counsel for the applicant. Paragraphs 472 through 473 of the ICJ nuclear test case makes clear that whether a binding unilateral declaration exists must be interpreted narrowly, and what matters is determining whether an obligation exists is the intent of the statement maker, not the interpretation of third parties. There is no evidence from the Rohadi minister himself that he had the intent to make a binding declaration, and more importantly, there's no indication that the state of Rahad wished him to make a binding declaration on that day, and the nuclear test case is not dispositive as to the issue of whether he had authority. Looking specifically to the statement that the ILSA report indicated a risk of harm to the area of the aquifer, what it merely indicated that was due to proximity of certain portions of the aquifer, care needed to be taken to not damage the complex. And what Rahad specifically did in light of the ILSA report was to move its operations entirely away from the portions of the aquifer that were near the complex. And rather than an indication that any drilling could lead to a risk of harm, I see my time has expired. May I briefly finish that thought, Your Excellency?
No. You
I
can
haven't
sit
done a rebuttal ever, so.
Yeah. I asked Connor to do a rebuttal specifically because of what you brought up. So we have a justice on our United States Supreme Court who's very well known for his silence. His name is Clarence Thomas, and in his 30-year tenure on the court, he has spoken once during his oral arguments. So Professor Vasileska has mirrored our learned Justice Thomas, not in his policy, we hope, but perhaps in his demeanor. Just well done, you guys. Well done. Well done for you guys, because you haven't done this in 2 months. So congratulations on retaining a lot of your memory. I asked the two of you to be here to listen to what they said, but I did not see you taking notes.
I recorded.
Ah, very well. Oh, and I will stop recording. So good.